There's a chill sweeping through the content creator world right now, and it's not from the algorithm. It's something colder, more calculated, and it's coming directly from Blake Lively's legal team. Just days after her case against Jed Wallace was publicly dismissed in a quiet but humiliating turn of events, Blake has unleashed a new offensive, this time not on celebrities, not on studios, not even on journalists, but on content creators. Yes, the very people who gave this story its reach, its oxygen, and its heartbeat. And the timing, it's not a coincidence. This is about control, image repair, and an increasingly desperate attempt to shift the narrative. But the most shocking twist, these subpoenas aren't just asking for commentary or emails, they're asking for bank records. Let that sink in. Creators who simply discussed public court documents and media coverage are now being asked to reveal financial information. Why? Because Blake's team appears to be building a new theory that talking about her online, especially in a critical tone, is somehow a monetized conspiracy against her reputation. But here's the truth, this isn't about money, this is about fear. Blake Lively just watched her own case collapse in front of the very audience she tried to silence. And now, instead of accepting that the narrative moved beyond her control, she's trying to yank it back by any means necessary. And that's where this story begins. Jed Wallace was never a major player in the grand scheme of Hollywood. A well-connected fixer, maybe a consultant. Someone who moved in and out of boardrooms quietly, but for Blake Lively he became a symbol, a scapegoat. When things started unraveling between her and Justin Baldoni, Wallace's name surfaced in confidential filings, accused of leaking private negotiations, manipulating statements, and pushing a narrative favorable to Baldoni. But when the court finally looked at the evidence, something became stunningly clear: there wasn't any. No emails, no texts, no proof, just assumptions. The judge's decision to dismiss the case against Wallace was brief but damning. The language wasn't inflammatory, but it didn't need to be. Insufficient evidence, lack of material connection, no reasonable claim to proceed. Those phrases hit like thunder in Lively's camp, and they knew it. Because once Wallace walked away unscathed, the domino started to fall. What else had been assumed? What other names had been thrown into the fire with flimsy proof? And more importantly, who might be next in the days following the Wallace dismissal? A disturbing pattern began to emerge. Multiple independent YouTubers, TikTokers, and commentators, many of whom had covered Blake's legal battle from the beginning, started receiving letters from her legal team, not cease and desists, not even formal lawsuits, subpoenas, and not just any subpoenas. These were surgical, detailed, and deeply invasive. They weren't just asking for the content creators' footage or sources. They were asking for monetization data from platforms like YouTube, Patreon, and TikTok, personal banking records connected to brand sponsorships, communication between creators and third-party researchers, email records with legal analysts who had spoken publicly about the case, and shockingly lists of viewers who had donated or supported videos through platforms like Ko-fi and Buy Me Coffee. To say the creator world was stunned would be an understatement. Some initially thought it was a hoax. Others laughed it off until they saw the actual court-stamped paperwork. Blake wasn't joking. She was officially treating online commentary as a financial conspiracy to damage her brand, and she wanted to expose who was behind it and who was benefiting. Soon after the subpoenas became public, Blake Lively's legal team issued a carefully worded press statement to Variety, claiming that the goal was not to silence creators but to trace the coordinated amplification of false and damaging narratives. The statement continued: public commentary that misrepresents legal facts and court proceedings, especially for profit, falls under a different standard of scrutiny. Our subpoenas seek to identify whether individuals knowingly spread falsehoods while benefiting financially from reputational harm inflicted upon Ms. Lively. This line raised red flags for legal analysts across the board, because the implication here is huge. If Blake's team is successful in framing independent commentary as malicious, profit-driven disinformation, it could redefine how public figures go after creators. In court, it could open the door to lawsuits, not based on defamation but on financial damages from narrative shaping. In simpler terms, talking about celebrities online could become legally risky, even when it's based on public information. And that's terrifying. Brian Friedman, attorney for Justin Baldoni, didn't hold back when asked about the subpoenas. It's intimidation, plain and simple, he said in a phone interview. When you lose a case like Jed Wallace's and your next move is to go after YouTubers and commentators, that's not about the law, that's about ego. That's about trying to bury voices that embarrassed you. He added that no court in the country has ever upheld the idea that simply earning ad revenue from commentary constitutes conspiracy or targeted defamation. This is a fishing expedition, Friedman said. And courts don't like fishing expeditions, especially when they target speech. Other First Amendment scholars chimed in as well, calling the subpoenas a potential chilling effect on creator-driven media and a misuse of civil litigation tools to enforce PR control. Still, Blake's team is pressing forward, and it's becoming clear they're not backing down. According to multiple insiders close to the legal teams, this move was in the works for weeks. Some claim Blake's team was enraged by the sheer number of viral videos breaking down the courtroom developments, especially the ones that exposed contradictions in her filings. One legal insider revealed there was a war room meeting the day after the Wallace ruling. They didn't just talk about how to pivot legally, they had YouTube clips on a monitor. They were analyzing who said what, how many views it got, and what timestamps were damaging. This means they aren't just reacting emotionally, they're building a strategy. A PR legal hybrid that sees creators not as random critics but as organized players in an image war. Some believe Lively is preparing a broader legal theory to file an amended defamation complaint, not just against Baldoni but against a list of creators who in her team's view monetized her pain. That phrase alone, monetized her pain, is becoming a rallying cry in Hollywood legal circles. Because if that theory holds, anyone with a platform could be at risk. By the time the dust settled from the Jed Wallace dismissal, the subpoenas had already gone out, quietly, surgically. Blake Lively's legal team wasn't blasting them in the press. They were sending them straight to inboxes and attorneys, each one stamped official and worded with unnerving precision. Among the first to be hit were creators who had steadily covered the Lively versus Baldoni conflict since the beginning. These weren't gossip channels or drama chasers. These were independent commentators, media breakdown analysts, legal explainers, many of whom based their videos entirely on public court documents. Creators like a legal YouTuber who dissected the filings line by line, a former PR executive with a commentary podcast discussing celebrity crisis management, a TikToker known for summarizing real-time courtroom developments, a mid-sized creator who had shared leaked emails that were later confirmed by the court to be authentic. What they had in common: reach, accuracy, and viral impact. Some had videos topping 2 million views with titles like Blake Lively's legal strategy just collapsed and why the judge threw out her evidence. Others were quoted in articles by Rolling Stone, Insider, and The Hollywood Reporter. To Blake's team, these creators weren't just critics, they were narrative architects. And they had to be stopped, but stopping them through reputation damage wasn't working. So Lively's attorneys shifted strategy: follow the money. Here's the legal innovation Blake's team seems to be testing. Instead of simply accusing creators of defamation, which is notoriously difficult to prove when it involves public figures, her lawyers are exploring a more novel angle: unjust enrichment. The argument that these creators financially benefited from videos that damaged Blake's reputation and that those benefits can be recovered or used to prove coordinated intent. The documents mention monetization via AdSense, viewer tips on live streams, brand deals gained after covering the scandal, Patreon income related to exclusive breakdowns, paid speaking gigs, or podcast appearances discussing the trial. It's not a traditional approach, but it's aggressive, and that's the point. By turning basic creator monetization into evidence, Lively's lawyers are reframing the whole narrative. It's no longer about opinions. It's about commerce and damage. One redacted subpoena even requested all documentation related to revenue generation tied to content involving or referencing Ms. Lively or any party named in Wallace v. Lively et al. The chilling effect palpable. The response from the creator community was fast and fierce. Most were stunned that their commentary could warrant this level of scrutiny. A few spoke out immediately: I never thought reading a court document out loud would get me a subpoena. TikTok creator with 600K followers: they want my bank records for what? Explaining a legal ruling that's already published. YouTube legal analyst with 300K subscribers. Others went dark. Accounts went private. Live streams were canceled. One popular content creator who was documenting the subpoena's impact simply posted, lawyered up. Updates soon, stay safe. Some have already filed motions to quash the subpoenas, arguing that the requests are overly broad, invasive, and intended to intimidate. Legal watchdogs are watching closely to see how judges will respond, because if these subpoenas stand, it could set a new alarming precedent. Behind the scenes, whispers of a digital blacklist have started to circulate. Some PR insiders claim that certain creator names are now being tracked by studios and reps, not officially but informally. If you post too many anti-Lively videos, you might notice fewer invites, fewer press passes. One entertainment journalist shared anonymously, "People are watching now." Another insider described a growing sentiment in elite circles that online Commentary needs standards, which some creators see as a polite way of saying censorship. What's even more concerning is the involvement of Ryan Reynolds. While Blake Lively remains the face of this legal push, sources close to the matter are suggesting that Ryan Reynolds may be far more involved than he appears. According to leaked emails and private DMs circulated among journalists, Reynolds has been deeply concerned about how the online narrative has affected their brand both personally and professionally. One email reportedly written by a PR strategist in Reynolds' team mentions the need to neutralize creator disinformation before brand equity takes permanent damage. Another leaked message allegedly between a lawyer and a talent agency rep quotes Reynolds as saying, "If they're making money talking about us, we have every right to know who they are and how much they made." While Reynolds hasn't commented publicly, insiders believe he's been encouraging the move toward aggressive discovery and even funding some of the legal expenses related to creator subpoenas. If true, it changes everything. This isn't just a legal battle anymore. It's a coordinated branding war involving one of the most powerful couples in Hollywood. And they're taking no prisoners. Not everyone is impressed by Blake's strategy. In a roundtable discussion aired on Court, four lawyers unanimously criticized the subpoenas as overreach. One compared them to Hollywood's version of the Streisand effect, warning that the attempt to suppress creators could make the story even bigger. Another expert added there's a constitutional right to comment on public court proceedings. If these subpoenas are upheld, it sends a dangerous message: speak out and we'll subpoena your life. The ACLU is reportedly watching the case closely. If one of the motions to quash goes to federal court, it could trigger a wider civil liberties challenge. In short, Blake's camp may have overplayed their hand. With the subpoenas out and backlash building, Blake Lively's legal team is walking a tightrope. Public sentiment is shifting and fast. Even fans who once supported her are beginning to question the optics. Why is she going after creators when she just lost a case with no evidence? This feels like revenge, not justice. What is she hiding that she's so scared of people talking? And those questions are becoming harder to ignore. Even before the Jed Wallace case collapsed in court, Blake Lively's legal team appears to have been preparing to escalate the fight quietly, methodically, and strategically, thanks to a leaked chain of internal emails shared with The Intercept, and later verified by two independent legal consultants. We now know that the subpoenas to content creators weren't just a last-minute reaction, they were already drafted. The email thread in question is dated nearly 3 weeks before the Wallace dismissal. In it, an associate attorney from Lively's legal team writes, "We need to prepare a list of high-impact commentary sources. Anyone generating viral coverage or monetizing our client's legal image should be tracked for possible discovery." Another email in the chain, sent by a PR strategist working closely with Blake and Ryan's branding agency, suggests the following: we should consider subpoenas, not just for defamation, but to identify financial incentives driving these narratives. If they're profiting from her pain, that's a story. This phrase, profiting from her pain, keeps surfacing. And it's clear now that this wasn't just a legal defense, it was part of a media strategy. One meant to reframe public perception from Blake as aggressor to Blake as victim of an internet monetization machine. But now that the emails are public, they raise new questions. Was the Wallace case ever really about justice, or was it a stepping stone in a much broader war on digital media? And more urgently, if Blake's team is doing this, who might be next in the wake of the backlash surrounding the subpoenas? Several major Hollywood players began circulating internal memos. At the center of the storm, a now confirmed closed-door legal summit, held just days after the Jed Wallace dismissal, hosted quietly at a private venue in Beverly Hills. Attendees included representatives from major PR firms, high-profile celebrity attorneys, crisis consultants who manage reputational damage, executives from two leading streaming platforms, legal counsel from Blake and Ryan's joint brand ventures. According to someone who attended the meeting under the promise of anonymity, the focus was clear: how to control the creator narrative. They were brainstorming frameworks, not just legal ones, but cultural. Like, how do we convince people that monetized commentary is dangerous, that it's invasive, that it's wrong? One strategy discussed equating viral commentary with digital exploitation. The idea was to build a public-facing campaign around the notion that creators are turning celebrity trauma into clicks and that there should be consequences. Another suggestion was even more controversial. They floated the idea of a Responsible Creator Act, basically a lobbying push for legislation that would allow more control over how public figures are covered in monetized media. This isn't just about Blake Lively anymore. It's about a system of influence trying to turn public sentiment against independent voices. But the creator community isn't staying quiet. In fact, in the face of escalating pressure, many are banding together, forming informal alliances, consulting First Amendment attorneys, and preparing counter-campaigns. One creator with over 800K subscribers on YouTube posted a now viral video titled "I Got a Subpoena from Blake Lively, Here's What I Won't Do." In it they say this isn't about truth, this is about power, this is about famous people who got used to controlling the headlines and can't handle what happens when we start reading court filings ourselves. Another prominent creator tweeted, "If you're afraid of commentary, maybe don't start a public court war in the first place. We're not here to babysit your brand." Others are stepping up to educate audiences, posting breakdowns of how subpoenas work, what rights creators have, and how to resist discovery abuse. Several law firms have offered pro bono support to targeted commentators, arguing that these subpoenas may violate journalistic protections, especially when the creators are clearly engaged in public interest discourse. The message from the creator world is growing louder. We're not going anywhere. Blake Lively was once seen as a Hollywood darling, graceful, private, smart, and beloved for keeping her family life guarded. But this legal crusade has cracked that image wide open. Public sentiment is turning, and fast. Polls run by media watchdog groups show a marked shift. 62% of respondents now believe Blake is going too far. 74% say they support creators' rights to discuss public legal proceedings. 49% view the subpoenas as abuse of power. Even casual fans are expressing disillusionment. On Reddit, a top comment under a recent Blake-related post reads, "She's not protecting her reputation. She's destroying it, one creator at a time." And on TikTok, the hashtag boycott Blake hashtag has crossed 3 million views, with users highlighting the hypocrisy of someone who uses the media when it suits her but tries to silence it when it doesn't. Meanwhile, Justin Baldoni and his legal team are watching this situation unfold with a measured but knowing silence. While they've avoided fanning the flame, sources close to Baldoni say he feels vindicated by what's happening. The tactics speak for themselves, one insider noted. Blake's trying to turn this into a moral war over money and messaging, but the facts remain. Her strongest claim was just thrown out, and instead of rebuilding, she's burning bridges. Some speculate that Baldoni's team is preparing to file a motion that will bring the subpoenas into question within his own legal battle, potentially framing them as retaliatory or a form of legal intimidation meant to chill open discussion. If that happens, Blake may be facing not just bad PR but a counteroffensive in court. As the dust continues to swirl round Blake Lively's dramatic legal moves, one thing is crystal clear: this is no longer just a lawsuit. It's a seismic moment in the culture war between celebrity image control and independent digital commentary. What started as a high-profile case involving Jed Wallace and allegations of leaks has now spiraled into a broader campaign targeting content creators. And not just for what they say, but for how they earn a living while saying it. The subpoenas Blake's legal team sent out demanding access to creators' bank records, monetization data, and private communications represent a chilling precedent. It's not only unprecedented, it's strategic. This isn't about proving defamation in court, it's about pressuring, silencing, and scaring. It's about reclaiming narrative power in an era where that power no longer solely belongs to publicists or magazine covers, it belongs to platforms, screens, voices, and to the people who choose to tell the story as it unfolds. But here's where it gets even more striking. Instead of sympathy, Blake is facing growing resistance. Creators are banding together, legal experts are calling out her team's tactics. Even fans are pulling back. And the public, they're watching with skepticism, asking whether this legal campaign is really about justice or about revenge against voices she couldn't control. Blake Lively's brand, once celebrated for elegance and poise, is now tangled in a messy public confrontation with the very internet culture that once embraced her. And while she may have once enjoyed the privilege of curating her image, those days are gone. In the digital age, you don't get to handpick your critics. You don't get to silence coverage that makes you uncomfortable. And you don't get to rewrite court outcomes by chasing creators into legal battles they never asked for. What's happening now is bigger than one celebrity. It's about whether creators have the right to comment on public events without being financially or legally threatened. It's about whether discussing a court filing or a PR strategy can land you on the wrong side of a billionaire-backed legal team. And it's about whether truth, commentary, and community can survive in a world where power is used to intimidate instead of inspire. In the end, the public will decide what this story really means. Not the lawyers, not the strategists, not even Blake herself. Because once the court of public opinion starts paying attention, it's impossible to shut it off. And in this case, it's watching closer than ever.